So good morning, ladies and gentlemen. It's my great pleasure to open this Working Group 2 session that will take the form of a colloquium. Simply to explain for those who are not familiar with the UNCITRAL terminology, a colloquium is a much more open forum to discuss the work to be done. And it then goes back to a working group that actually performs the legislative work, and therefore we are very pleased to have a very large participation in this colloquium. We have about 670 people connecting online, and we have 30 very brave participants in person, which means that we are turning to a real hybrid session. We are, of course, cognizant of the difficulties that the time frame we have chosen for this colloquium imposes on those participating from Asia. And we will I'm therefore not going to make a long introduction. I will simply wish you wholeheartedly a good and productive colloquium, which means a lot of discussion and brainstorming. And we really very much look forward. And I will, without further delay, give the floor to the chair of Working Group 2, who will proceed with the adoption of the Working Group's agenda and guide us through the next steps for the colloquium. You have the floor, Andres.
Thank you very much, Madam Secretary. Good morning, good afternoon, and good evening to those that are physically present in New York, as well as those that are joining online. Welcome to our 75th session, as evidenced by the number, an important milestone for our working group. I am sorry I couldn't attend in person this time, but by seeing a number of you in New York, I'm happy that we are returning somehow to normality. A new normality indeed, as is shown by the large numbers of those attending online. Our first point of order is to approve the agenda for the session. I have not received any comments on the proposed agenda as was indicated in the letter that I sent to the working group, so the agenda can be considered adopted. As indicated in the agenda, this session will be organized in the form of a colloquium on possible future work for the working group. The colloquium will discuss four topics that, following the decision on the Commission, are identified in the agenda. Development in dispute resolution in the digital economy, online platform for dispute resolution, technology-related disputes resolution, and adjudication. Sessions will be moderated mostly by the members of the secretariat. I will be moderating the roundtable discussion on Friday. Please note that the report of the colloquium will be prepared by the secretariat for consideration by the Commission, and that no report of the Working Group 2 will be adopted this week. Before passing on the floor to our first moderator, let me thank very warmly the Secretariat for the great work in preparing this session, as they usually do, and for the working papers that were prepared to serve as the basis of our discussion this week. Thank you very much again. As to our first topic, DRDE, developments in dispute resolution in the digital economy, we have the luxury to have as a moderator Anne-Jovan Brett, the Secretary of UNCITRAL. Madam Secretary, you have the floor.
Thank you very much, Chair. And without further introduction, since you have all the bio notes of the speakers in the UNCITRAL website for Working Group 2 and for this colloquium more specifically, I will give the floor to Takashi Takashima, who is who has been acting as the rapporteur for our working group for the past 2 years or 3 years. He's a senior attorney with the Ministry of Justice of Japan, and he will introduce for us the project that was presented by the government of Japan to UNCITRAL at the Commission last year, which had as its purpose to take stock of the developments in the digital economy, of dispute resolution in the digital economy, that, as we have all seen, has been accelerated, not triggered because the technology was already available, but definitely accelerated by the COVID pandemic. And this project could not come more timely to allow us to take stock of these developments and see how, from taking stock, what is the work that UNCITRAL could do in order to remain fully in line with the practice that we see in the many disputes across the world. So I would like to give the floor to Takashi, who will provide us with the background of the DRDE project. Again, DRDE in our beloved UN acronyms is dispute resolution in the digital economy. So when you hear DRDE, that is what it stands for. And Takashi will explain in further details what we will be looking at in this project. Takashi, you have the floor.
Thank you very much, Madam Secretary, for the floor and for your very kind introduction. It is my great honor to be the first speaker at this colloquium. Distinguished representatives and participants, as one of the key contributors to the project, I am delighted to take a moment to provide an overview of the project entitled Stock Taking and Development and Dispute Resolution in the Digital Economy. Can we turn to the next slide, please? On other occasions, I have had the pleasure of discussing the background in terms of what prompted Japan to propose this project in 2020 and contribute to setting it up since. Still, I think it's worth a look at where we started. At a glance, I wish to touch on 4 key points which were considered. First, digitalization. Even before the pandemic, digitalization had been a long and gradual trend in various aspects of international trade, including dispute resolution. Second, the pandemic. The pandemic brought a sense of urgency and accelerated digitalization, but it also prompted us to think further about the need to address the disruptive aspects of digitalization. It made us reaffirm the need to contemplate how best resilience towards global crises may be improved and modernization achieved. Third, the significance of dispute resolution. We thought dispute resolution deserved special attention because it was the cornerstone in bringing proper settlement of disputes, access to and prevalence of justice. Fourth, the availability of a feasible approach. In this regard, we came up with a practical and feasible approach for the project, which was to monitor the changing landscape of dispute resolution, the evolving practices, and the development of new forms of dispute resolution. Next slide, please. I would like to briefly go through the history of the project. It was at UNCITRAL session in 2020 that Japan put forward a proposal that the Secretariat be vested with a mandate to conduct relevant activities to monitor the changing landscape of international dispute resolution. At its session in July 2021, the Commission approved the implementation of the stock-taking project. In December 2021, the stock-taking project was subsequently approved by the United Nations General Assembly. I wish to add that in January this year, as pledged, the government of Japan contributed the funds necessary for the implementation of the project in its entirety. Next slide, please.
Takashi, before you start with the next slide, could you speak a little bit slower, please, so that we are
yes.
sure that it's captured by our interpreters? Thank you.
I will do so, Madam Secretary, with apologies. In parallel, work has been conducted to define the scope of the stock-taking project. UNCITRAL, the Ministry of Justice of Japan, and other institutions co-organized a series of online discussions, starting with the kickoff discussion in February 2021, which was followed by a DRDE workshop in March the same year. The latest of the discussions were those during the 2021 Tokyo Forum on Dispute Resolution in December 2021. Speaking of the project's scope, it is also noteworthy that the Commission at its session in 2021 acknowledged that it was widely felt that the stock-taking would need to take into account the disruptive aspects of digitalization, in particular with respect to due process and fairness. Next slide, please. The latest discussions which took place at the 2021 Tokyo Forum on Dispute Resolution were suggestive of areas for the project activities. The summary of the discussions and the suggested areas of work for the project are contained in Japan's submission, Working Paper 222. The suggested areas of work are equality and fairness issues, arising from the use of technology in arbitration, addressing the flood of information problem, appropriate use of dispute resolution on online platforms, online hearings and witness examination, online mediation. In the time remaining, I wish to provide a gist of Working Paper 222. Equality and fairness issues arising from the use of technology in arbitration concerns the imbalance of technological means leveraged between the parties. For example, if one party to the dispute used virtual reality and other advanced technology to present its case, whereas the other party relies solely on PDF, Word documents, and PowerPoint slides to present its case, this raises a couple of questions to be asked. Would this not create equality and fairness issues? Under the same situation, if the arbitral tribunal imposed on the parties to both use advanced technology, wouldn't this also create equality and fairness issues on the party which is not familiar with technological means? What are the technological means used in practice? And how are equality and fairness issues pertaining to their use addressed? These are the kinds of questions to be asked on this very topic. With respect to addressing the flood of information problem, digitalization is said to have solved the physical storage problem of paper-based records, but at the same time aggravated the flood of information problem. With increased digitalization, the parties are less incentivized to limit their electronic documents to those most relevant and are conversely encouraged to submit whatever is available, putting the arbitrators at risk of being overwhelmed with irrelevant information and unable to respond to the core disputed issue. In this regard, some questions to be addressed by the project may include, for example, how has practice taken action to address this serious problem? What are the existing rules on case management which may be utilized to address this problem? What are the practical steps and procedural approaches to address this problem? As for appropriate use of dispute resolution on online platforms, acknowledging that new forms of dispute resolution on online platforms have emerged, the project may attempt to respond to questions such as what new forms of dispute resolution other than arbitration and mediation exist on online platforms? What types of disputes are best resolved on online platforms? Does dispute resolution on online platforms give rise to concerns on due process, fairness, and accountabilities? These questions may be usefully asked to contemplate whether there may be any need for standards setting forth preconditions such as informed consent on the use of dispute resolution on online platforms. In terms of online hearings and witness examination, this is an area where abundant information seems to already exist. There is a question as to whether a right to a physical hearing exists in jurisdictions around the world and whether the global situation on the matter warrants a development or revision of existing legal instruments, including the UNCITRAL model arbitration law. Practice has evolved so that parties are ensured their essential due process rights in an online setting in the form of various protocols and guidelines, and there seems to be much to be studied in this regard. Finally, on online mediation, which is another area increasingly attracting attention since the onset of the pandemic, protocols and guidelines are being developed and used for the conduct of online mediation. When texts applicable to the conduct of online mediation are negotiated, there is an issue as to the party being reluctant to negotiate what was proposed by the other party, as this may risk giving the initiative to the proposing party. To this issue, it was said that prearranged texts may provide a solution, which demonstrated the potential need for research on the various texts available and used in practice. In Working Paper 222, it is suggested that relevant information on the areas just discussed may be obtained through a comprehensive study of various dispute settlement means in different jurisdictions and legal systems. May I kindly ask that the slides be put off, please. Madam Secretary, this brings me to the end of my presentation, and I wish to conclude by adding my wishes for fruitful discussions on the scope of the stock-taking project. Thank you, and back to you, Madam Secretary.
Thank you very much, Takashi, for this very comprehensive overview of the different elements of the DRDE project, and for bringing it back to the fundamental principles of due process, fairness, and equality, and also the indicating possible outcomes in the form of standards to reaffirm these important principles. So thank you very much for this introduction, which allows us to go straight into the approach that has been taken by two arbitration institutions, and particularly we will start looking at the ICC's task force findings on leveraging technology in dispute resolution. And I'm very pleased to give the floor to Stephanie Cohen to introduce for us the findings of this task force of the ICC. Stephanie, you have the floor.
Thank you. Distinguished representatives, it's a pleasure to share insight from the most recent report of the ICC Commission on Arbitration in ADR, which is entitled Leveraging Technology for Fair, Effective, and Efficient International Arbitration Proceedings. As many of you will be aware, the ICC Commission is a global body organized by the International Chamber of Commerce that brings together 850 experts and practitioners in the field of arbitration from over 100 countries. Not unlike the initiative that brings us here today, the Commission's recent work on technology and international arbitration was prompted by the pandemic and the acceleration of the existing trend toward increased digitalization of our practice. But the final work product, published in February of 2022, very much seeks to provide practical guidance regarding how technology may be better leveraged for efficient and effective proceedings going forward. As part of our mandate, we were fortunate to draw upon external feedback from two prominent sources. The first was country-specific feedback from ICC national committees. This focused on a few discrete issues that posed potential concerns about recognition and enforcement of arbitral awards arising from the use of technology, including electronic notifications of requests for arbitration, terms of reference, communications during proceedings and awards, as well as electronic signatures of terms of reference and awards. A multi-jurisdictional analysis of these issues was beyond the scope of our report, but it did reveal that there's significant uncertainty about mandatory law in this area. And this, I believe, is a potential obstacle to greater use of electronic signatures and notifications for awards in particular as we move forward. So I would flag this as an area that is deserving of greater attention. The second major source of feedback that we were able to draw upon was a practitioner survey to establish a baseline about what technology is being used and not being used in international arbitration practice, as well as prevailing attitudes toward technology. We conducted a survey about past, current, and future use of technology, which received more than 500 responses. A few of the survey findings are worth highlighting, as I believe they set the stage for this colloquium. First, 93% of respondents agreed that technology has improved efficiency and cost effectiveness of arbitration. 83% believed that technology is being underutilized. Now, on that note, a majority of respondents expressed a willingness, notwithstanding their past practice, to move toward paperless proceedings, at least up until the arbitration hearing, to make greater use of online case management platforms for the exchange of all or most communications and submissions, and also agreed that there should be no presumption in favor of in-person evidentiary hearings or remote evidentiary hearings, but rather that a determination should be made in each case in the circumstances of that case. Their survey also demonstrated unfamiliarity with detailed existing resources on technology, such as the ICA New York City Bar CPR Cybersecurity Protocol on International Arbitration. And this, I think, reveals a different kind of flood of information problem. It also revealed meaningful concern about what we refer to as the digital divide. More than 1/3 of respondents believe that cost or inadequate infrastructure and resources have posed barriers to technology being incorporated effectively in their past international arbitration matters. And just over 1/4 believe that technology has created or exacerbated concerns about fairness or equal treatment of the parties. So the recommendations in our report very much focused on these findings. So in the time that remains, let me just give you a brief overview of the approach that we took, taking into account those findings. First, it was important for us to begin with a general and flexible framework of issues to consider for the selection and implementation of technology tools and solutions in the arbitration process, including, of course, fundamental principles of equality and fairness. But we also made mention of a concept that has received less attention, but surely will more going forward, and that is the notion of technological competence and a potential significance in arbitrator selection going forward. The report also places significant emphasis on the importance of early case management. This, of course, is nothing new. And it is notable that more detailed discussion and guidance with respect to issues that are covered in the report are already flagged by the well-known UNCITRAL notes on organizing arbitral proceedings. Some of the points that we would flag for attention with respect to early case management in general terms included attention to the specific IT tools being proposed, the timing and manner of their implementation, the associated costs, and the IT sophistication and experience of the tribunal, the parties, and other relevant IT users involved in the arbitration. We also noted that there are multiple drivers influencing the selection and implementation of technology tools. For choosing particular tools may include considerations of time and cost to enhance case presentation and the tribunal's understanding of the case, issues of confidentiality, cybersecurity, or compliance with data protection rules, just to give a few examples. Last, we also thought it very important that the report be accessible and practical, that it avoid technical jargon. We sought to consolidate what international arbitration practitioners need to know in one place. And in that regard, an important component of the report is a series of organizational checklists that are contained in the appendices to the report. A number of these are aimed at facilitating virtual hearings and selection of online case management platforms. There is also sample procedural language for procedural orders, including a template order for the conduct of evidentiary hearings by video conference. Of course, in this, the focus on remote or virtual hearings was an important one as we emerge out of the pandemic, and so we built on existing guidance, but also address elements that have received less attention, such as with respect to the selection and use of third-party service providers and hybrid hearings. We also highlighted issues with respect to the digital divide, encouraging, for example, the development of regional hearing facilities and interinstitutional cooperation to facilitate equality of infrastructure and access. To a certain extent, these appendices standardize points of practice that have evolved over the last 2 years. And this, I would flag, is important for those who are less familiar to be able to work with templates that may still be tailored for their individual case, to allow them to avoid some of the biggest potential pitfalls that may exist with respect to issues such as cybersecurity, for example, and not to be overwhelmed. But the tech-savvy need reminders too. And so it was also an important focus in developing these checklists that they assist with efficiency to make it easier to implement technology and minimize concerns about disruption and technical incident, and allow practitioners and arbitrators to keep attention and focus on the proceedings themselves and not on the technology that is being used to facilitate the process. Thank you.
Thank you very much, Stephanie. Thank you for flagging an issue that we have very much at the heart of our work on digital trade, which is technological neutrality and ensuring that the technology does not overwhelm the users. And thank you for flagging that, because I think it's really an important point. And the second point you're making also resonates very much with UNCITRAL, particularly its early work on electronic signature and non-discrimination, which is the basis of UNCITRAL's rule on electronic commerce, non-discrimination between paper and non-paper data and documents, and also the use of electronic signature. So it brings us closer to this area of electronic commerce that is also one of the pillars of UNCITRAL's work. So thank you very much for that. And I'm giving the floor now to Sarah McEachern from the IBA, who is going to present to us the findings of an IBA report on technology resources available in international arbitration. So the floor is yours, Sarah.
Thank you. Distinguished representatives, it is an honor to be here to discuss the IBA's guide on technological tools for arbitration practitioners. The use of technology in dispute resolution, as I'm sure we all know, is here to stay. For many of us, there are ever-changing technological tools that we can engage to improve the dispute resolution process. As just mentioned by Representative Stephanie Cohen in summarizing the ICC survey, the implementation of some of these tools has increased by necessity throughout the pandemic, and there is an increased demand for the implementation of these tools. But how to keep abreast of all of the many and varied developments in the technology? How do we address technological competence, another topic referred to by Ms. Cohen and in the survey? How to determine which of these tools are the most worthwhile learning about and implementing in dispute resolution. The IBA ARB 40 committee published a guide in March 2019 on technology resources for arbitration practitioners to address some of these very concerns that were being raised already at that time. It was recognized that there was a need for a resource that draws together a selection of the different software programs, applications, and offerings related to the use of technology by arbitration practitioners. Advances in technology, of course, can be utilized by practitioners, parties, arbitrators, as well as the users of arbitration themselves, the clients, to make arbitration and dispute resolution potentially more efficient, cost-effective, secure, and dynamic. But of course, we're not all at the same level of familiarity with the resources available. And of course, not all parties will have access to the same tools. Even for those of us who have access, some arbitration users may find it challenging to keep current with the latest tools and developments. This online, free and neutral guide was developed by the IBA ARB 40 subcommittee as a first step towards making modern arbitration technology more accessible to practitioners. What we have done is gathered a list of currently available technological tools and compiled them into various categories as a kind of user-friendly reference for arbitration users. So on this slide here, you can see what I would like to do in the remaining time is just walk you through what is offered on the website in the event that this may be a useful resource and orient you within it. So essentially there are 8 categories, and I'll go through each of them in brief. And also you'll see here at the very top the latest technological tools to support virtual arbitrations. That's a category that we added at the I guess about 6 months into the pandemic, because those tools that we've gathered under that link are the most useful for the virtual arbitrations, which of course we've had to turn to through necessity. So just a quick overview of these topics. The first one is audio and video conferencing, which I'll go into in a bit more detail in a moment, but I'm sure we're all very well familiar with that now. Document collection, review, and production is the next one, followed by management and transfer of arbitration data. Now, these are programs that could serve as a platform to host, manage, organize, sort, and transfer the voluminous documents and submissions that are used and exchanged in arbitration. Most basic platforms of this type would be cloud-based, and they would serve as a repository for the data, allowing users to upload and share their materials. Again, this opens up other issues, which I know will be referred to throughout this session in terms of cybersecurity and the like. There's also a section on the presentation of graphics and evidence in disputes. These would be software applications that have been utilized by counsel to complement the oral pleadings by using illustrations, etc. The most basic would be PowerPoint, as used here, but there are others selection available under this category as well. Virtual reality and augmented reality, I will discuss a bit later in the presentation. Analytical tools and mind mapping. These would be software applications to help lawyers develop and explore facts and legal issues displayed in a logical, often visual structure. These analytical tools could be used to map case strategies, identify critical information, and uncover patterns, relationships, priorities, trends, and the like. Translation and interpretation, it's fairly straightforward, and I'm sure everyone here is very well familiar with what those tools can offer. But in the digital age, it's applications that could be used to provide simultaneous translation or machine translation of documents. Cybersecurity and data privacy. This is an area of increasing concern and relevance. Maintaining security and privacy of documents and information is obviously of a critical importance, and these would be some of the tools available. So to the next slide 4, please. At the commencement of the pandemic, as I said, the drafters of the guide reconvened to provide a one-stop shop, so to speak, for the tools for virtual arbitrations. Now, I would have liked to share the actual website with you, but what I've done is I've just taken screenshots to show you what it looks like. If you go to the next slide, please. So if you click on any one of the links, you will then have a selection, a drop down, and then you could click on any one of these items, and it will provide you with a summary of what that tool is or does. So let's look at the way that at one of these categories, if you go to, so under, actually just stay on, thank you, next slide please, virtual hearing platforms. So you can see here, if you were to click on Zoom, it will tell you how the document's going to be used on Zoom, that there are breakout rooms, there's a text chat functionality. So it's meant as a kind of primer on each of these sites, for those who may be looking for what's the best tool for your particular situation, or if something's being proposed and you're not familiar with it, this may be a good resource to go to find out a bit more information. Next slide, please. So the category of document collection, review, and production, obviously this is a really big one in international arbitration, probably the most commonly used tool, at least prior to the pandemic. We have put a number of resources here. They're broken down into 3 categories: document review platforms, software artificial intelligence applications for document review, and specialized vendors. So under the, thank you, software AI applications, for example, it's then further broken down, and we've provided a summary at the beginning of what the various types of technology would be able to be used for. Everything here from auto redaction, review of documents in unstructured formats like text messages and the like, non-linear review, so being able to have clusters of information, show flow of data, social network visualization, technology-assisted review, continuous active learning, and those types of concepts is what would be used here. So in each category, what we did is we explained a bit about the way the technology is used, and then we provided, if you can just go, oh, well, this is, just go back to the previous slide for a moment, thank you. If you look at the bottom there, you can see a list of applications. So this isn't meant to be an exhaustive list. There are just simply too many different tools, and they're changing too rapidly to be able to offer that. But it's a starting place to find some of the most commonly used apps. And in order to compile these categories and lists, what we did is we consulted with the various users in the IBA, ARB40 and beyond, and to see which programs were being utilized. Slide 9. Another example is the virtual reality and augmented reality, and I noted that in the paper from the representative from Japan, there was a note that this is still a relatively new development to the market. However, these technologies that allow, this is kind of like the virtual reality, kind of like computer games and the like, they're still relatively new and not being used that much in dispute resolution, but we may see in the future additional adoption of these types of technologies, such as to explore, let's say in a virtual hearing, the actual construction site that is in dispute in a proceeding. So those provide some examples of the types of categories and technologies that are available in the guide. In my final slide, I just want to conclude a couple of comments on the implications of the use of technology in dispute resolution. These tools have potential to improve dispute resolution and even improve access to justice through virtual hearings, for example. But as mentioned by distinguished representative from Japan, Mr. Takashima, we must be mindful that the use of these tools could lead to a lack of procedural fairness, as there may be unequal access to technology. Not all users will have equal familiarity with the tools. To date, tribunals have acted in some cases as gatekeepers to ensure an element of fairness and balance in the use of technology. As mentioned by Ms. Cohen, the implementation of a procedural order to address these issues, as she mentioned, there may be available as a template through the ICC, could be a very useful and helpful tool in addressing this. Further thought on whether certain guidelines could be adopted on the use of technology in dispute resolution is necessary in these quickly changing times. Distinguished representatives, that concludes my high-level overview of the Guide on Technology Resources for Arbitration Practitioners. I hope you may find this website a useful source of point of reference for users going forward. Thank you for your kind attention.
Thank you very much, Sarah. Thank you for unbundling for us so aptly the different technologies that we are putting together under digital dispute resolution. So thank you for this very detailed presentation. So we've heard from the ICC a report survey of these technological developments. We've heard from the IBA a very interesting overview of all the technology resources available. We would like to hear now from practitioners on the way they see this evolution and whether we are faced with a paradigm shift or whether we are simply moving one step further into digitalization, or whether there is an actual disruption by all this technology and the technological developments, and how this can be addressed. So I'm very pleased to give the floor to Lisa Alm. For those of you who were familiar with Toby first? Okay, so thank you. I'm told Toby first. So generally it's ladies first. This time we will do it otherwise, and I will first give the floor to Toby Landau. Toby Landau is a barrister and arbitrator in the Singapore group practice of Duxton Hill Chambers. And he's well known for those of you who participated in the negotiation, the development of the UNCITRAL transparency rules, where he represented the United Kingdom. So Toby, you know UNCITRAL inside out, and you know arbitration inside out. What are your views about these technological developments and the disruptions they bring with them? The floor is yours.
Thank you so much. Distinguished representatives, it is a great honor to speak at this colloquium and provide a practitioner's perspective. Let me start from the year 2020, looking back very briefly. I would suggest that if you look back from that moment, say 5 or 10 years, there were 3 fundamental changes that had taken place in the practice of international arbitration. Firstly, a marked widening in reach of the dispute resolution process, both in terms of subject matter and participants. So the process has been expanding over ever more sectors and areas of economic activity, and it's been including ever more numbers of participants from broader geographical stretches and reaches. That has been accompanied with an expansion in the number of international arbitral institutions, well beyond America and Western Europe, through to Asia and Africa and South America and beyond. And also the marked expansion of academic coverage, so that our whole process is now coupled with greater scrutiny, many specialized courses, treatises, journals, and the advent of breaking news, which we receive in our email inboxes on a daily basis. Secondly, there has been, of course, the rise of investor-state dispute settlement, which has put a spotlight on our standardized model of international arbitration and subjected it to greater scrutiny. And thirdly, alongside those two, of course, there has been the emergence of digital applications and increasing availability of digital technology. Video conferencing, as we've already heard, hearing platforms, electronic bundles, cloud-based case management platforms, and newfangled ways of presenting the case. Now, I start with all of those because even at 2020, the combination of those 3 factors, in my view, put a number of stresses on our conventional arbitration procedural model. They have led to calls for greater accountability, greater scrutiny. Legitimacy questions have come to light, calls for transparency and against confidentiality. And on top of that, but related to all of this, an increasing concern about redundancy and inefficiency in the way that we conduct the process. That is in terms of excessive costs, delays, and a procedural mechanism that's been seen as cumbersome, overly automatic, not flexible enough, and too much peppered with boilerplate provisions. Now, if one then stops at that point from looking back at 2020 and consider what then happened, we walked straight into the pandemic. The pandemic forced an abrupt, unexpected step change on all of us. We were all shunted into a digital world. And it's interesting, in my view, to see how we've reacted to that, because the initial phase was to try and transpose that existing procedural model onto an online form, into an online form. So we started at the early part of the pandemic to try to recreate what we used to do in person in a remote setting. But what we have now learnt, what we've realized, is that we cannot do that.
Toby, can you hear us? You're being thwarted by technology, I fear. Could you try to reconnect, please?
Yes.
Okay, good. Over to you.
Can you hear me now?
Yes, perfectly.
Yes, I'm not quite sure at what point you lost me, I'm sorry. But what I was saying is that what the pandemic brought was a step change, unexpected, abrupt step change, where we were forced onto an online platform, in essence. And we've learned that we cannot simply recreate what we were doing before in this new but
We lost you. We lost you again, Toby, when you were saying that we cannot recreate online what we used to have before. So we lost you again almost at the same time.
I'm so sorry. I'm speaking from Pakistan, and I'm afraid the connection is failing me. Can you hear me now?
We can.
So very briefly, what we have learnt from the new environment is that we actually have to now reconsider our standardized procedural model. The digital revolution that we've now experienced shows that actually the thought and all the stresses in the system that we had before the pandemic can actually be addressed by a new form of dispute resolution, new form of arbitration, which deals with the technology and allows the technology to reshape the process. We have more accessibility now to arbitration than ever before. More people can participate than ever before. Case management is much easier now. Hearings are easier to assemble and arrange. They can be much more frequent. And there is now scope to rethink our process with the benefit of all this new technology. And so that, for me, frames the debate for this colloquium. We have the ability now to use technology, and we should do so to actually answer the stresses that have been in the arbitration system for a while now, and see this as an extraordinary opportunity to actually recharacterize.
Toby, sorry, but we've lost you again. So maybe we can move to the next speaker. I'm really sorry, Toby, to have to cut you. Can you hear us?
I can. I'm sorry. The connection has failed me.
Yes.
It may be that, I don't know how much of that you caught. Whether you'd like me to summarize, we'll move on.
We caught your message of the ability we have now to use technology as an opportunity to rethink international dispute resolution, particularly arbitration, and maybe we lost a little bit at the end.
I think that is you've captured the main message, which is to see the shunt into the digital world as a great opportunity to reconsider and resolve the stresses that had built up in the process over a period of time up to the pandemic.
Well, thank you very much for this very clear message, and apologies again for these technological disruptions, but I think they make very much the case to the point. I will now, without further ado, give the floor to Lisa Alm, simply to remind those of you who have seen Lisa in her previous functions as the digital transformation person for the Stockholm Chamber of Commerce Center of Arbitration. Lisa has moved on, and she's now the Chief Strategy Officer at World Favor, but still very keen and interested in digital developments in dispute resolution. So over to you, Lisa, please.
Thank you, and thank you, Madam Secretary and distinguished delegates. Thank you so much for the opportunity to address you all today. I will spend my 8 minutes with you racing through a tip of the iceberg style presentation of some of the developments and changes that we can see when it comes to the use of technology in dispute resolution. And I apologize in advance that this will be a little bit of a tech buzzword bingo, but then I am now in the tech and startup world, and we do love our buzzwords. So now there's a lot happening in this landscape, and I will start with an overview of examples from where we can see the technology coming into the different phases of dispute resolution. So starting with the solutions that help you prepare and manage the process, and many of these are referenced already today by Ms. Cohen and other speakers. And these are either trying to replace a process entirely or support a specific part of them. So the examples you can see here are platforms that help you find optimized venues or cases in, for instance, class actions. You see the use of a predictive AI to analyze the likely outcome of cases, time or cost predictions, and so forth. And you have more and less sophisticated databases for arbitrator searches. You have end-to-end platforms, especially for consumer disputes. And then you have various case management tools, e-bundles, virtual hearing, all of that. So these tools generally try to make the process more efficient. And to Mr. Landau's point, that is extremely important. Some of these might benefit from our assistance, and some of them might raise concern. But in the larger scheme, I would say that they are less complex than the next category, which is solutions that are targeting, next slide, please, how to resolve the dispute. So here you got various solutions trying to either help you settle the case using, for instance, escalation solutions where you have logics and guided processes, or you have various blind bidding processes like a blind auction. Now, both of these are sometimes coupled with an automated or templated settlement agreements. But these are solutions that are mainly trying to get the parties to agree amicably. And then you have the solutions targeting adjudication of the dispute in one way or the other. You do have some predictive AI solutions budding, and then you have game theory, crowdsourced, non-expert solutions, and that's when you hit the buzzword bingo. But I understand that you will be hearing more about that over the coming days. So these are really exciting from a tech perspective, and they also give rise to more complex questions from a legal perspective. When it comes to the last step of dispute resolution, which is the enforcement, development doesn't seem to have come quite as far yet. And unfortunately, my minutes are way too short to dive into some of what might be coming here. So I'll leave you with a little teaser that a trend that you may want to keep an eye out for is blockchain awards or the various kinds of automated awards. In this context, it will also be exciting to see what the Singapore Convention might open up for. So I guess we have reason to return to that. So what are then the challenges if we want to promote, or for that matter, restrict some of these solutions? Now, as I see it, the challenges that we're facing are relating to either the underlying technology, to the access to the technology, or to legislation legacy. When it comes to the technology in of itself, there are multiple challenges inherent in, for instance, the use of AI or machine learning and blockchains in the judiciary. Again, I'll refrain from elaborating in fear of overstepping my allotted time, resting assured that this is something that is being addressed quite regularly in debate and also by UNCITRAL and others, and rightly so. The other issue is the question of access to technology. Access to technology, no, sorry, go back and slide. Access to technology might be the next access to justice, in that sophisticated technology might be increasingly necessary to claim your right. As the distinguished representative from Japan, Mr. Takashima, referenced earlier, an uneven distribution of the access to technology might lead to inequality of arms between parties and thus an unbalanced process. And lastly, there are challenges with the legislation, and I think almost more importantly with legacy when it comes to implementation of technology. Some legislation might need updating, both to promote and safe up the use of tech, and some of the built-in safeguards in current legislation might be rendered less effective by automatic enforcement, for instance, or by the use of technology for certain aspects of the process. When it comes to legacy, arbitration was created to be flexible, and I think at its core, it might stand the test of both time and technology quite okay. However, best practices and habits that have built up over time might be too confining to allow for the changes that we want to see. And habits might even be harder to change than legislation. So where does that leave us? What should the UNCITRAL do? Now you can swap. There you go. In order to focus our efforts, we can either look at the areas which we're currently seeing the most adoption, or where we see the most potential issues. Today, technology is mostly used as supporting tools when you prepare or you manage your disputes, as most of the examples today have related to. increased use of often tried and tested technology to make the current processes more efficient. This is being addressed in several workflows already, inside and outside UNCITRAL, and there is still plenty to do in this area. Now, I would argue that the area that has the most potent technology, both in terms of its ability to bring on change, and when it comes to the potentially challenging the rule of law, is artificial intelligence, which makes that another great area for UNCITRAL to focus on. So to conclude, technology is reshaping both the how and the why of international dispute resolution, and that's a great thing. It holds both promises and challenges, and as Mr. Landau said, this is a great opportunity. So on that note, I will end with this visualization of our role here today. The UNCITRAL needs to be both the promoters of technology and the guardians of the rule of law at the same time. And I admit that I may have watched a few too many superhero movies, but standing here, well, digitally, standing here today, addressing the member states of the UN, my heroes carrying briefcases and takeaway lattes rather than capes, it still feels like an appropriate vision to have here. Because together we're taking on the fight, we're making sure that we are using advanced technology to fix the world, but also making sure that we protect it from any harm that it may cause. So fortunately, there's a lot of guardians out there, and there's a lot of work being done in this field, and you will hear more from my fellow guardians of the galaxy in the next coming days. So with that, distinguished delegates, thank you so much for your time.
Thank you very much, dear Lisa, for this very in-depth introduction of the tip of the iceberg. And as you rightly pointed out, all these technologies have developed or were already there. But we have also heard at the introduction by Takashi Takashima that these technological developments and their impact on international dispute resolution have really been accelerated or triggered by the pandemic. And we are going to hear now from Kim Rooney, who's joining us from Asia, and I thank her very much for keeping awake at this late time of the day, to tell us more about a study that was carried out on dispute resolution, the way the pandemic has impacted dispute resolution, and the way different jurisdictions have reacted to this technological solutions. So over to you, Kim, for the last presentation of this cluster of this morning. Thank you. Kim, we cannot hear you. Are you online? Maybe you'll have to do something with your microphone, because we can see you, but we can't hear you. You are on mute, apparently.
Can you hear me now?
Yes, we can. Loud and clear. Up to you.
Sorry, I've taken my headset off. I apologize. I will start again. Please forgive me. My technology failed. Thank you. Thank you, Madam Secretary, distinguished representatives and participants. It is a great honour to share with you the key findings of the study of the global impact of the COVID-19 pandemic on commercial dispute resolution and relevant legislation in 23 jurisdictions, to share the key findings. Next slide, please. This study was done for Dispute Resolution International, which is the IBA's Journal for Contentious Committees that I edit. We prepared 2 articles on the global impact of the pandemic on commercial dispute resolution. The first published in October 2020, the second published in May 2021. You can see the links to the articles there. We had 46 contributors from 23 jurisdictions who reviewed the impact of the COVID-19 pandemic on litigation, arbitration, and ADR, including mediation. Next slide, please. We had contributors from 23 jurisdictions from each continent, and you'll see there from Africa, Asia Pacific and region, Europe, UK, MENAT, North America, and South America. Next slide, please. What we observed, and you've already heard about some of the trends, is there were marked contrasts among the jurisdictions with regard to their openness to innovation and their capacity to rapidly adapt. Now, part of the explanation was a disparate capacity in finance, technology, and human resources, but some of it was the degree of flexibility of the legal framework and culture of a specific jurisdiction. And you'll see in the article, each article is a schedule which sets out substantive and temporary laws and regulations generally, and then specifically for first litigation, legislation and codes and guidelines, and second arbitration, legislation and guidelines and similar. Next slide, please. As we've been hearing today, the pandemic has led to an accelerated use, but also a development of technology for use in all forms of dispute resolution. And that has demonstrated how fit actually mediation has been. That was one of the findings, that mediation had really flourished. Now, we've already been hearing about the various ways that this digital technology is being used, and I won't go through that again as time is short. Next slide, please. But in terms of innovation, the digital technology that we found was being used as of 2021 included, and some speakers have mentioned this already, blockchain, including for case management, auto-transcription, document management and automated docketing, cloud storage, inferential artificial intelligence, natural language processing and visual perception tools, and importantly, autonomous decision-making, acts caused by algorithms without human intervention, ADM, which I'll return to. And the innovation has also been, as we've heard, flexible scheduling and with regard to costs. Next slide, please. Now, as we've also heard today, there's been a great flurry of activity in the development of practice notes and guidelines, including as to procedural fairness, efficiency, cybersecurity, data privacy and confidentiality, and logistics. There's also been increasing regulation at a national and provincial level, and also at the political or in political and economic unions of states, including the EU. Next slide, please. When we did this review first in 2020, we found that most of the legislation was posed as being temporary, whether for use of online platforms, remote hearings, use of alternative dispute resolution, public health orders, quarantines, etc., and suspension of time limits, payment obligations, and insolvency triggers. By 2021, there was a trend towards permanent and legislation, in other words, legislation that provided the framework for some of these initiatives or innovations to continue, including online courts, online platforms, increasing work being done on access, use and transfer, including cross-border, cybersecurity, and, as we've been talking about already, use of artificial intelligence. Next slide, please. What were the issues that came up? Well, unsurprisingly, many were in common with what we've been hearing about today. These included the variable capacity of jurisdictions to innovate, issues of access to, use and transfer of data across borders in this big data age, inconsistent legal frameworks and practices giving rise to conflicts of law issues, fairness, efficiency issues, issues of cybersecurity, new causes of action developing, and query whether or not, as the speaker's already said, arbitration is fit for purpose for all of these. and new forms, combinations of dispute resolution. The increasing impact of automated decision-making, impact on costs, as some have said, yes, it can definitely reduce costs, that is advanced digital technology, but it can also add to costs. And unequal access to resources, the access to justice issue, and that leads into the effectiveness of the current international legal framework. Next slide, please. We were asked to comment briefly on whether we respectfully suggested there could be more work done on harmonising legal standards and contents. I would respectfully suggest UNCITRAL has plenty to do in this area. International framework developed in the pre-digital age, as we all know. We are now in a digital age of big data. The dispute resolution landscape, our first speaker was speaking about it, it has changed. And it has changed and it will continue to change. And these changes impact on arbitrability, jurisdiction and arbitration agreements, fairness and procedural standards. We've already been talking about some of them: authentication, transparency and disclosure, equality of treatment, rights of affected third parties, these new forms, combinations of dispute resolution and enforcement issues. Increasingly, issues about data access, use and transfers, and the issues of privacy and confidentiality that also arise. The issues of digital technology use and standards, including cybersecurity, and also liability, who's responsible if things go wrong, and we've been hearing about technological neutrality, automated decision-making, and the issues that arise, including the use of AI and the Internet of Things and other digital technology, and finally, and of course, most importantly, access to justice and equality. Thank you very much, Madam Secretary.
Thank you very much, Kim, for this extremely detailed presentation and the various suggestions you're making at the end in terms of way forward that are duly noted and that we will start to take on board now in the discussion, which is going to involve Working Group 2 representatives. So we're moving from the experts into the Working Group 2 delegates, and where we will hear from 4 of them the different perspectives, either regional or maybe more focused on 1 or 2 of the elements, the core principles that we heard about this morning. But I will start by giving the floor to Andrés Hanna from Chile, our chair of Working Group 2, to share with us the Latin American perspective. Andrés, you have the floor.
No. I was not there. Yeah, I was not able to get the microphone on. Well, thank you very much, Anna, and thank you very much for the invitation to speak now as delegate and also sharing the experience and developments in Latin America. As I usually say, Latin America is not one single entity with one reality. This is particularly true with arbitration and other methods of ADR. Together with the cases administered by large arbitral institutions such as the ICC, are many arbitration centers in the region, some of them very active and experienced in administering cases, including international dispute, and others much local and with less experience. The same can be said with respect to the normative environment applicable to the cases, the experience and sophistication of practitioners, as well as the access to technology. That means that there are many realities, and therefore a good care has to be taken and is needed when generalizations are made. But on the other hand, there are common problems that appear to a certain extent in most Latin American jurisdictions, and I would say, in my experience, also in other parts of the world. All of that, all of the above is reflected in the use of technology, and I would say in particularly the responses to the COVID-19 across the region that cannot be left aside of the analysis because, as you said, and as was said at the beginning, Madam Secretary, accelerated the use of technology and created a change in the landscape that we have to take into account. So what I would like to do is to make 3 comments coming from that experience in the Latin American region, which is obviously extensible to the use of technology currently, including remote, hybrid, and physical hearings and proceedings. The first point I wanted to make is about the value of models and protocols. In the most developed centers in Latin America, Lima, Bogota, in Sao Paulo, notes and guides were adopted very quickly in different with respect to how to deal with the technology, remote hearings, etc., during the pandemic. But I would say that for me, one of the relevant experiences in the region is the importance of having access to guides or models that reflecting best practices at the regional, international level will help the region in 2 ways. One is harmonization, and the second is the know-how for less developed and experienced centers and practitioners. A good example of that is the protocol created by the Permanent Observatory on arbitration that was created by the Latin American Arbitration Association called ALARB. The idea of the observatory was to review in a permanent way the situation in the region, and they asked for different opinions of different arbitral centers and practitioners with respect to what's going on due to the effects of the pandemic. As a consequence, what the observatory identified were disparities of experiences on holding of remote hearings, including lack of uniformity, and how they were conducted among countries and arbitral centers across the region. And the problems inherent to remote hearings also received different answers in different arbitration centers in Latin America. It's issues such as equality of the parties, security and confidentiality of information and documents, and objections to remote formats for conducting hearings, just to mention a few. The observatory also the value in issuing a general protocol for conducting remote hearings in arbitration that will serve as a guide for holding virtual hearings with the purpose of providing arbitration centers and practitioners in the Latin American region with a tool that incorporates the best practices, building on the regional and international experiences. The tool is meant to serve as a guide to arbitration centers, arbitrators, and practitioners, and is built as a general instrument, notwithstanding that may have to be adapted considering different legal frameworks of the countries and the centers. The protocol has been very successful, I would say in particular because allow less developed local centers to have a tool where they can, as I said, implement remote hearings and have access to a know-how, tips, and experiences in order to introduce that within their arbitration. And I think that is a good example of the usefulness of considering instruments at the regional level that, notwithstanding the different realities, may serve to harmonize standards and practices, taking into account local but also international reality. The second point that I want to make is that the importance and the need for access to logistics and availability of services. A problem that is possible to see in all types of international arbitrations, even those administered by major international arbitrations in the region, is the difficulty of having access to proper platforms of services by third parties, for example, to conduct remote hearing. And this is particularly true when it comes to medium to small arbitrations, where counsel are less experienced and funds are more limited to pay for these services. And this could make a big difference in the proper conduction of the hearing and all the problems associated with it. I would say that something that I've been seeing of particular relevance is the proper technological capabilities. It means human, but also technical, in order to be able to properly conduct the proceedings on the arbitrators, the parties, and the centers. And I would say very specifically the issue of interpretation. I've been dealing as an arbitrator counsel in several cases that especially across regions of the world that require interpretation services. And I have to say, it's very difficult to find the good quality of service, especially in certain languages. Asian languages, for example, that has been my experience. And that creates a very significant problem in order to really have a proper multilingual hearing. And that's something that would have to be taken into consideration, in my view, is any further development of remote hearing and technological services. And the last point that I want to make is taking on the point made by Toby Landau. I agree with him that this is not the same. Technologies change arbitration, but we don't have to lose sight that now that we are somehow past the pandemic and we are somehow coming back to hearings that have some technological aspect but other that don't, we don't have to lose sight of what is the core aspect of what we do. And the core aspect of what we do is to adjudicate cases. It's true in an efficient manner, but also in a fair manner. And therefore, we don't have to lose sight, and that's been my experience in many cases that I'm involved, that technology has to be at the service, but cannot obscure the fact of what is the core purpose. And in that sense, it's true that arbitration has been reshaped, but it still is the same activity that tries to provide a fair procedure in order to, solve a dispute in an efficient manner for the parties. Thank you very much.
Thank you very much, Andres, for reminding us about the essentials and not getting carried away by technology, which is, I think, one of the points that have been recurrently made by the presenters prior to your intervention, that technology is a tool and it's not an end in itself, and it should not, if I may say, wag the tail of the dog. So I will now, without further ado, give the floor to James Castello, also a delegate to Working Group 2, to talk to us about the experience in Europe and the United States of these new technologies at the service of international arbitration. Over to you, James.
Thank you very much, Anna. Can you hear me? Yes, okay. So as you say, I've been asked to focus on how advances in information technology have affected arbitration in Europe and also to some extent the United States. Let me just say at the outset that although, as you mentioned, I've been privileged to be part of this U.S. delegation for a couple of decades, I'm speaking just as a private practitioner who's based in Europe. The distinguished delegation of Japan's very helpful working paper 222 identifies 5 categories of questions relating to arbitration in the digital age. And given my limited time, I'm just going to focus on 2 of them that have been particularly discussed, I think, in Europe and the United States. One is the question of online hearings and witness examinations, which is topic D. And the other is whether the increased use of information technology in arbitration introduces problems of inequality and unfairness and unequal access to the process, and that's topic A. Now, as Japan notes, the pandemic greatly accelerated the incidence of online hearings, but we need to remember that such incidence was growing even before the pandemic, and Japan references the 2018 arbitration survey by Queen Mary University, which found that video conferencing was already used in arbitration either frequently or always by 60% of the survey respondents. And in Europe, I would say there have been at least 3 reasons for this growth, and I think they're likely to contribute to further growth in online hearings in the future. The first is that the national laws governing at least 3 of the world's 5 most popular arbitral seats, which is London, Paris, and Geneva, and obviously those are all located in Europe, do not expressly require a physical hearing in arbitration. And this information comes from the national report submitted to ICA's project on whether there's a right to a physical hearing. Now, those same reports suggest that perhaps the only European jurisdiction that may require, under its law, a physical hearing is Sweden. Moreover, the two most widely used institutional arbitration rules in Europe, which is the ICC and the LCIA's rules, have been expressly amended to confirm that tribunals have full authority after consulting the parties to decide whether a hearing shall be in person or remote. Now, second, I think there's also an increasing concern about the carbon footprint created by in-person arbitral hearings, which for large cases may require as many as 40 lawyers, witnesses, experts, arbitrators, and party representatives to fly hundreds or thousands of miles to a designated seat, and they may stay in air-conditioned or heated hotels for 10 days or more. So the Campaign for Greener Arbitrations, founded in 2019, which won the 2020 award for Best New Development from Global Arbitration Review, has especially expanded, I think, our awareness of this environmental impact. And one of the campaign's 6 green protocols on arbitral proceedings talks about the possibility of having all hearings performed by video conference. A third reason, I think, is simply that parties have recognized that having remote hearings can shorten the time and also reduce the costs. Especially when you have 3-member tribunals or a council who are in great demand, it's often easier to find dates for a remote hearing than trying to build in a longer period that accommodates travel to and from an arbitral seat. Now, notably, the Queen Mary's survey found that not only are 60% of participants already using online hearings frequently or always, and that was before the pandemic, but that they also, 89% of them thought that there would be greater use of video conferencing in arbitration in the future. Now, there's, I think, been relatively little disagreement among parties that at least for procedural steps in the arbitration, like a case management conference, remote hearing offers sufficient opportunity to present arguments effectively. But I think there's less agreement on merits hearings. And that's a much more delicate question. Like many practitioners, I have participated during the COVID-19 period in arbitrations in which both parties agreed that a merits hearing could fairly be held by remote mode, even if there was cross-examination of numerous witnesses. But I've also faced circumstances in which at least one party felt strongly that an in-person hearing was essential to have a fair opportunity to present its case. A party may feel, for example, that a tribunal must be able to assess the demeanor and the credibility of crucial witnesses face-to-face, or they may even feel that counsel must be able to present oral argument making real eye contact with the arbitrators in order to make the case properly. Now, if you have two parties who disagree on this point, that is really a situation where a tribunal will have to make a difficult decision. Let me just echo what Andres Hanna said, that I think one situation which can really make an argument for an in-person hearing is precisely when you have key witnesses who are testifying in a language that none of the arbitrators understands, which is to say through interpreters. And if all the parties, the witness, the counsel, the interpreter, and the tribunal are all in different remote locations, then if you have deficient interpretation, and that may happen for many reasons, including the fact that the witness has a different accent or a different dialect than the interpreter, then you can have a real recipe for problems which are more easily untangled if you are all in person. The important point I just want to leave on this issue is that the actual human interaction may be important, and when the tribunal tries to resolve that issue, it's often going to be on real factual details of the case. And therefore, when I look at Japan's paper 1222, it refers frequently to the possible developments of standards, protocols, and guidelines. And my own feeling is I rather doubt that it would be wise or feasible to draft guidance of such a firm nature as to when to hold a remote hearing. And I think it's more likely, if UNCITRAL were to develop an instrument in this area, that it would be more like the notes that we have done on organizing proceeding. It would be something like the notes on how to incorporate information technology in hearings. And I would just note in that regard that if you look at some of the instruments, and many speakers have talked about how many instruments there already are in this area, if you look, for example, at the ICC document, it's denominated a checklist for a protocol on virtual hearings. And if you look at that document, it's more an itemization of the decisions that parties and tribunals will have to make rather than a guide as to how they should make those decisions. Let me just say a couple of closing words on topic A, which is whether the use of technological means gives rise to concerns on equality and fairness. The working paper again notes parties' concerns that technology may result in inequality on costs or uneven distribution of technology, and it cites a statistic of 26% of the responses from the ICC's national committees expressing such a view. I think it's important to explore these concerns, but also it's not the case that using information technology, such as for remote hearings, will necessarily create these kinds of concerns. And here, several points might be made. First, the question should not be, as I have heard some smaller enterprises say, for example, that using technology has costs. Rather, the question should be whether those costs are less than what the costs would be if the party were otherwise to participate in person. And as we know, typically those costs are quite high. The same ICC survey of national committees confirmed from 93% of the responses that technology improved cost effectiveness and efficiency in those national committees' views. Second, even relatively modest costs that may be incurred, such as buying a new external camera and microphone for a laptop, which can really improve the participation in a remote hearing, is a cost that will likely be amortized by the law firm or even the in-house counsel over many hearings. Third, often institutional facilities near the location of a remote witness or a remote expert can be rented for relatively modest costs to avoid having to purchase or install high-quality equipment in a party's or a witness's own premises. And fourth, and finally, costs may be initially equalized between parties if they jointly agree to retain the services of a consulting service, and there are a number that offer this now, which is specialized in setting up remote technology for all parties' participation in a remote hearing, and those costs are typically split equally at the outset, subject, of course, to the apportionment by the tribunal in a final award. So I think all of these approaches have been successfully used in arbitrations seated in Europe during the pandemic, and they should be taken into account in addressing the unfairness issue that Japan's paper quite properly raises. Thank you.
Thank you very much, James, for sharing the experience and the views from Europe and the United States. It's interesting that you're mentioning both the carbon footprint and the importance of the in-person interaction that we've been seeing and experiencing in our work in UNCITRAL. But yet you also mentioned the issue of costs and efficiency, which is one of the elements that we haven't heard that much about so far, and the elements of comparison that you raised. So thank you very much for that, for sharing your views on that. And I'm going to give now the floor to two of our delegates in Working Group 2 to talk about the element of fairness that you all have picked up as being the essential principle that has been identified also in Working Paper 222. And we're going to listen first to Jae-min Lee from Korea and listen to his views about ensuring fairness in the dispute resolution in the digital economy. Jae-min, you have the floor.
Madam Secretary, thank you. Good morning, good afternoon, and good evening to everyone. I'd like to start by thanking the Secretariat for organizing this colloquium and the opportunity to talk about these important issues. Well, next slide, please. Well, again, let me underscore the importance of this topic, DRDE, and the timeliness of the topic. We have seen the rise of the new norms, and yet we are looking at these norms from the ad hoc basis and fragmented approach. So it appears that a harmonized rules and harmonized guidance will facilitate the introduction and the implementation of this new the dispute settlement mechanism in DRDE. So it appears that this is a good topic for Working Group 2 discussion in terms of its legislative work. Next slide, please. There are some things that we can consider. The first one is that what is exactly being demanded from the market? The DRDE seems to be very broad. It includes technology. It includes very different type, wide range of logistical issues, technical issues, and the new challenges. So the key question is how to determine and clarify the scope. In order to do so, we need to determine what is exactly being demanded from the market. And what is in that process, also we need to think about the due process topic, and also from the practical challenges that we are facing from the virtual hearings or online dispute settlement proceedings. Because this topic is just so broad, we need to prioritize our times and resources for key topics so that we can working group complete the process in a feasible manner for the next 2 to 3 years of discussion. So the key question is, again, how to clarify the scope and how to prioritize our time and limited resources for future discussion in this important area of future discussion. Next slide, please. Next slide, please. Thank you. So again, as highlighted before, I think due process issue is at the core of the future discussion of DRDE norm discussion at the Working Group 2. Well, due process is an integral part of any dispute settlement mechanism, but it becomes more important, and it becomes a particularly important topic in DRDE because of its technological aspect and the embedded structure of technology divide. So it is an important topic. The due process is an important topic in discussing DRDE for the legislative guidelines at the Working Group 2. And at the same time, again, I think it's important for us to separate the pure or important due process issues from practical challenges that we'll have to face in a virtual setting. Well, for instance, there is a logistical issues. For instance, interpretation, or the authority to organize, the authority to convene the meeting, who convenes the meeting, or the facility issue. And at the same time, there's also technical issue, such as technical glitches, or the internet connection, and the platform selection. And also there's a practical issue, such as time zone, and Zoom fatigue, and cost implication. Well, all these issues have some relevance to the due process concern. But at the same time, some of these issues are stemming from the embedded nature of virtual hearings or online meetings or video conferencing. So the key question mark is how to separate the practical issues that are embedded in the peculiar format of virtual hearings or online meetings or video conferencing versus the due process concerns, due process issues that we can consider in our future discussion of Working Group 2. So again, that leads us to how to prioritize our limited time and resources for future discussion. Well, just purely by way of example, we could focus on issues such as, for instance, client, expert, and witness coaching issue in a virtual setting, and also security, confidentiality issue in virtual hearings. And what about the recordings in virtual hearings in terms of, again, due process consideration, key aspect of due process consideration? And what about the possible disproportionate impact on hybrid format of meeting? And also, what about the different approaches to different forms of dispute settlement proceedings? For instance, commercial arbitration, where confidentiality is a default rule, versus investment arbitration, where now transparency seems to be the default rule. And what about mediation? Or do we have to take a different stance toward expedited arbitration in terms of virtual hearings? So we need to consider all these different modes in considering due process issues in the virtual settings. And perhaps we could also consider new modality, such as arbitration clause, which incorporates virtual settings as well, and how to handle key technical issues, such as camera specifications, or breakout rooms, or direct messaging format. So those technical features can also be addressed from the due process perspective in future discussions of the working group. And finally, we could also consider a coordinator, virtual hearing coordinator, or case manager, whatever you may call, as a neutral party who can be in charge of the conduct of virtual hearing. So again, this is a timely topic which requires legislative work on the part of UNCITRAL, and due process seems to be at the core of the whole discussion. And the key question mark is that we cannot cover the entire universe of issues that may have some relevance to due process issues. So we need to prioritize those topics and those issues of due process that can benefit from our discussion for the next 2 or 3 years of discussion. Let me stop here. Thank you for listening. Thank you for listening.
Thank you very much, Jae-min, for narrowing down to this core principle of due process, the discussions that we had in the morning, and for reminding us of the need to be open and conducive to new technologies, but also to be the guardians of due process in its development. So without further ado, I'm giving the floor to Judita Cordero-Moss, who's also a delegate in Working Group 2, and she will probably complement the presentation just made by Jae-min Lee, also looking into ensuring fairness in dispute resolution in the digital economy. Over to you, Judita.
Thank you, Madam Secretary. Yes, I would like to complement this very interesting and very pertinent and right contribution that we just heard. And in addition, I would like to come back to the question of the remote hearings that has already been touched upon a couple of times, because the issue of ensuring fairness can be linked quite evidently also to the question of how remote hearing actually work. We heard from the distinguished representative of the United States that there are very good reasons for having remote hearings, and at the same time there are also reasons for being a little bit skeptical, particularly when it comes to the merits, holding a merits hearing online. And it is particularly this resistance against merit hearings that I would like to address from the point of view of fairness of the proceeding and due process. In some legal traditions, the presence of all the parties in the same room is very clearly linked to the importance of the adversarial oral procedure, and there are even some arbitrators who consider it, and some parties as well, who consider it extremely important to come to the hearing completely unbiased, so without any very deep preparation, without having gone through written material. There are even resistances against having written witness statements because it is considered that the only proper way of listening to or evaluating the testimony of a witness is to look at the witness in the eyes and exercise the arbitral tribunal's own ability to read the person and to maybe to exercise some sixth sense or something like that. And indeed, when the hearing is taking place online, there is very little possibility to exercise a sixth sense or to read the witness in a proper way, which is one of the reasons why there is a certain resistance against online hearings when it comes to the merits. Now, what I think a possible role for the UNCITRAL could be is to try to develop some notes, as the representative of the United States was suggesting, some notes that try to cater for this impossibility to look in the eyes of the witness when the hearing is remote, because it does not necessarily mean that we cannot have remote hearings for the merits. It can mean that we need to adjust the whole process, actually, the whole procedure. For example, introduce more written materials, introduce more written witness statements, invite more active participation of the arbitral tribunal during the preparation of the hearing, and other possible measures that could compensate for the lack of physical hearing and the possibility to have real eye contact with the witness. So this is an area that is left to the discretion of the arbitral tribunal, and this is the area where the UNCITRAL has already written some notes, and it is also an area in which we have heard already earlier there are a lot of protocols and initiatives and programs that are meant to assist the arbitral tribunal in the exercise of its own discretion. However, I do not think there are a lot of initiatives that are focusing exactly on the necessity to adjust the whole process to compensate the lack of real eye contact with the witness. So this is an area in which notes developed by UNCITRAL could contribute to ensuring fairness of the process while permitting to preserve or develop and enhance the use of technology. Thank you.
Thank you very much, Giuditta, for having shared your views with us and for broadening, if I may say, the reflection or the thinking about what could be guidelines or what could help parties in facing online hearings. And thank you for narrowing it down also on online hearings, which is very much what we will be discussing at the beginning of this afternoon session. I'm sorry that we cannot have an actual discussion as we would have liked to have it now, because we are reaching the end of the morning session and we had some technical glitches that have taken these precious minutes of discussion away. But I hope that the afternoon session will enable us to have more discussion on the different points that we heard this morning on the need to embrace technology, the need to not be scared by technology, the need to ensure that the digital gap or the technology gap is taken into account so that parties are not favored by the different access to technology. So embracing technology, being conducive to the use of technology and what it brings as advantages to processes, and we've heard a number of them, but also being mindful of the need to preserve and protect the fundamental principles that underlie international dispute resolution as we know it and as it has been developed by UNCITRAL over the years, and see how we can both maybe learn from the approach of other working groups of UNCITRAL, which have tried to be conducive to technology without being hostage to technology. And I'm thinking particularly at the e-commerce working group and the principles that have come out of this working group, also on the use of, and I was reminded to by our speaker, Stephanie, at the very outset of the lack of appetite for using very, very basic principles of UNCITRAL on electronic signature, where there is still, I mean, the legal standards are there, but they're still not embraced and used in this particular industry of dispute resolution. So maybe that's also part of the thinking we could have, and also listening to the various contributions about the issues of costs, of efficiency, and the different tools that are available. So this has been a very rich morning session. I thank you very much for it. We are now at 1 o'clock on the dot. I would like to thank you all very much and look forward to your joining again either online or in the room at 3 o'clock sharp. Before I give the floor to my colleague who wants to say something in terms of, no, you don't, but I want to say that this afternoon there may be a change in the allocation of seats in the room because we see that, now we don't have social distancing anymore, but we could have a bit more space between delegations, take advantage of the fact that we're not all in the room again. So we will readjust the seat allocation. So when you come back, don't rush back to the seat you had this morning. You will have an opportunity to move around in the room. Thank you.